about your background as a lawyer.
So I come from South Africa. So I qualified as a lawyer in South Africa. Feels like a long time ago. It was a long time ago. Got admitted as a lawyer there in 1988, and then specialized as a litigation lawyer, where I was a partner in different law firms, which I built up significantly. Moved over to Australia in 2008 with a family, again back at university, which was a bit of an emotional roller coaster on its own. Qualified as a lawyer in Australia, in Sydney, in 2009. Carried on with litigation for a while. The one interesting story is I remember qualifying for my board exams in South Africa in 1988, walking out of those exams thinking, great, never have to write another exam in my life. And 20 years later, in 2008, back at Sydney University, studying again, now to qualify as a lawyer in Australia. Walked into a lecture late one day. Everyone sat down. They thought I was the lecturer.
Well, at least they thought that you were the person that was delivering the content.
Correct. At least I may have looked the part.
Yeah, you looked the part.
And then, very interesting, so litigation's in my blood, and I always thought I would continue with that. However, so many clients of my existing law firm in South Africa asked me when I informed them that I'm emigrating to Australia, how did you manage to do this? How did you get the visa? What did you do? So I actually started practicing in immigration law in Australia to assist my existing client base. And I became very passionate about immigration law and immigration to Australia, assisting people to migrate to Australia from any country. And ultimately started specializing in immigration law, which I found a new passion for, and kept doing litigation. But my core passion right now is immigration law for Australian immigration.
So, Phillip, can you give us one tip in the immigration space that might be of interest?
So the one tip that I would emphasize is, before you rush in and lodge your own visa application, go and consult an immigration lawyer and get expert upfront advice about your visa eligibility. So at least you know what you can and can't do. And the one thing you really want to avoid is applying for the wrong visa or applying for a visa where you're not eligible, and then you get a visa refusal. Especially if you get a visa refusal while you're in Australia, it's a disaster. You do not want to do that, because then you barred in almost every instance. There are one or two exceptions. They probably won't help you. So you then barred from applying for another visa in Australia if you get a visa refused in Australia and you're not on a substantive visa at the time, such as a bridging visa. Avoid that at all costs and consult an immigration lawyer or an experienced, reputable, emphasis on reputable immigration agent up front.
Okay, Phillip, thank you. That was very good advice. Now, I'd like to segue into a little bit of the human interest part of this interview series. Can you please tell us about your fashion style?
It's interesting, I guess, as lawyers, when you start practicing, you're very fashion conscious. And in my case, I was no different. My father, my late father, was a tailor from Savile Row in the UK. He emigrated, so another immigrant. He immigrated to South Africa when he was 19 as a tailor, and eventually started his own clothing factory specializing in making men's suits. Oh. And he told me, in fact, he emphasized when I qualified, telling me that even if I'm not the best lawyer in town, he will make sure that I'm the best dressed lawyer in town. So he would knock up my suits whether I wanted them or not. If I would go in there just for a quick visit, he would get one of his tailors to measure me up and choose some material And I had more suits than more suits than anything, probably more suits than underwear at that time. And it was fantastic. So I became very fashion conscious at that point. Became very specific about what I liked and what I didn't like. I even started choosing my lining in the jackets. For example, of course, those suits don't fit me anymore. Certainly the pants don't, but the jackets do. This is one jacket which I've converted into a sports jacket. I'm not sure if we can see the label. It's still got his label in. Again, very particular about the lining. I think I need to show you this, because this is something. It's not your standard lining. You can see the lining is quite diverse in the sleeves. So so as you get older, you sort of dress down, because as a lawyer, you just eventually, you're not as fashion conscious when you get older. Perhaps some people are. I'm not, as when you were younger. But there are certain things that are still very specific to me. The shirt is very important. I'll always make sure that I'm wearing a good shirt. In times of travel, Thomas Pink is my favorite brand. I would, if I'm in London or New York, make a point of going into Thomas Pink shop and stocking up with shirts. The other thing is shoes, and then always try and wear a decent watch.
Fabulous. Well, thank you for sharing that beautiful jacket with us. Do you find that when you are dressed up, or when you're dressed more formally, that it just it either makes you feel better, or clients respond to you differently? What are your comments on?
I think it does indeed make you feel better. As they say, you never get a second chance to make a first impression. So the first time you meet a client, it's critical to make that impression. So if I'm meeting a new client, I will certainly be very mindful of what I'm wearing. It probably in some subconscious way switches you on a lot more, because the minute you're dressed up, you're focused on that upcoming consultation. I never wear a tie anymore unless I have to go to court. That's my only irritant, if I can call that. But everything else is critically important as to how you dress.
Right. Thanks, Phillip. And you do wear a tie when you go to court. Is that correct?
Indeed, compulsory. So I at one stage I had a fantastic collection of ties, probably also Thomas Pink ties. Now I'll probably grab any old tie and just wrap it around my neck if I have to go to court for any reason.
But when you say compulsory, that's compulsory under your dress code. It's not compulsory for people listening that you need to wear a tie to court, or is it compulsory for men?
I would say it's compulsory for men.
Right.
If you are going to court, I don't think it would. A judge or magistrate will be very happy if you stood up and addressed them and you're not wearing a tie, as far as men are concerned.
All right. Thank you, Phillip, very much for that feedback. I would now like to move to the next part of the interview, which is the more substantive legal discussion. So for those of you who do not need to listen to this part of the interview, thank you for watching so far. So Phillip, can you talk to me a little bit about some of the matters that you're currently working on, or any matters of interest? I understand you're helping or assisting farmers to immigrate to Australia. Can you talk to us about that?
Yeah, so there's certain skill shortages in Australia that probably the average Australian even has no idea about. One of those skill shortages is the agricultural sector, which indeed is, being a food producing sector, is a very critical sector in Australia. It seems that there's a trend of no succession in the agricultural sector, where you've got these elderly farmers that have farmed and their families have farmed these farms for generations. And what I've seen in Australia is most of the children have no interest in farming at all. They're off to the cities and in universities. So you're having, firstly, no succession. And secondly, there are skill shortages in Australia with skilled farmers and skilled tradespeople who work on farms. such as a massive skill shortage is diesel mechanics. Who's going to repair the harvesters and the tractors? And I get calls from Australian farmers probably once or twice a week looking to match up candidates with my client base from South Africa. So the one sector that we do work in a lot is the agricultural sector, where we have skilled candidates from South Africa, farmers looking to move over and work in Australia. The dynamic for farmers in South Africa at the moment is not very good. Farmers are sort of on the wrong end of the political spectrum in South Africa. If you Google farm murders, farm crimes, land expropriation, there's sort of a stampede for South African farmers to get out of South Africa right now. And that works very well for Australia. There's a fantastic synergy between Australian farmers and South African farmers. It's sort of a culture on its own that just gels. So that's the one sector that we're working in primarily. But overall, we'll cover almost every kind of visa, from the bread and butter, employer-sponsored visas to protection visas. And what we specialize in as well is, as I mentioned earlier, people will often come and see me when they're in a visa mess, if I can emphasize that. And then we'll do the appeals to the Administrative Appeals Tribunal and to the Federal Circuit Court if there's grounds to do so. But that's, again, something that one wants to avoid. And honestly, one consultation, pay your $200-300, you can actually avoid that visa trauma.
Okay, got it. Phillip, I just want to go back to the farming immigration. So what is the current situation in Australia for these type? What sort of visa do these people have, or is there some lobbying that's been going on, which I understand you've been involved in, to help these farmers come into the country? Can you explain a little bit about the legal matrix?
Yes, of course. So it would fall under the broad spectrum of the subclass 482 employer-sponsored visas. And the Australian government, to some degree, is mindful of these skill shortages. So they've created what they call labor agreements. For example, there's the horticulture labor agreement with, I think it's 31 occupations, which would allow Australian farmers in the cropping sector to sponsor overseas skilled applicants and actually lower skilled applicants in a variety of occupations. Generally, one can come over on a 4-year visa. If you're under a labor agreement, or if you're under what they call designated migration agreements, where the federal government has entered into agreements with certain regional areas in Australia, there are pathways to permanent residence for people like the South African farmers or farmers from any country, I guess. It just seems that South African farmers fit in very well in filling the skill shortage gaps in Australian agriculture.
Are these farmers allowed to bring their families across with them?
They are. That's also interesting. Unlike the US and New Zealand, where we get contacted by South African farmers who are working in the US and New Zealand and they're on their own, they've had to leave their families behind. It is very favorable, yes. In Australia, if as a family unit, you can add your wife and kids generally to almost any kind of visa. Certainly the employer sponsored visas. So yes, they bring their families and kids, and that's of course very favorable to them.
Okay, got it. And what about the skill shortage in general for farmers? I mean, I know that during this COVID pandemic, there's not a lot of, or not as many foreign travelers coming in. What's the government looking to do about that?
It's a good question. Whatever they're looking to do, they're certainly not succeeding. There was some program to bring in workers from Vanuatu. Of course, now there's no backpackers. So, for example, yesterday I got a call from a sugarcane farmer in Australia, desperately looking for candidates to come in for the next 5 or 6 months. There's actually no visa that would cater for that if it's, let's say, lower skilled occupations. So in that regard, the government are actually doing nothing. often the government will embark on these fancy visa pathway programs, and quite often they're rubbish, if I can call it that. Great example, I spoke about the Dharma program. So that was created by the government, where they entered into agreements, labor agreements with certain regional areas. One area is Dabo. I went to which is part of the Arana Dharma, if we can call it that. I went to a conference in February. The title theme of the conference was More Jobs Than People. And when I spoke to the person running the Dharma program in that area, I asked her, well, how many employers have actually enrolled for the employer-sponsored Dharma visa program? And astoundingly, she told me 12. That's nothing. When I met some farmers privately in the Dabo region afterwards, none of them had even heard of the Dharma program. And it just hasn't been put out there. It's onerous, and it's just not working properly at the moment.
What is the Dharma program? Can you just differentiate that program from other visas?
It's part of the employer-sponsored visa program, but it's a separate agreement. Let's call it's a separate leg to the subclass 4A2 visa, where the federal government has entered into an agreement, let's say with Far North Queensland, for example, where one such program exists. And what it is, there's concessions, visa concessions, where they would not normally be on a subclass 4A2 visa, such as there could be an age concession, there could be an English concession. And the most important thing to the employer is there could be a salary concession where you can pay less than, let's say, they call it the TISMIT, the subclass 4A2 visa salary threshold. So there are, in theory, it works well. In practice, it's very cumbersome.
And why is it cumbersome?
Because there are so many steps hoops that you have to jump through to be able to sponsor somebody. Good question, that. So if a farmer is sponsoring a candidate on a subclass 4A2 visa, there are 3 steps. The farmer becomes a sponsor, the farmer lodges a nomination application relating to the position, and the visa applicant then lodges the visa. With a Dharma, firstly, the farmer has to become a sponsor, which is the same as what I've just mentioned. Secondly, they have to become a Dharma sponsor. So an added step, they have to now apply to the regional government to become, let's call it a recognized Dharma sponsor. Then you have to apply for a labor agreement, which is another step that's not normally anticipated, to the Department of Home Affairs. That drags out. Then before then you can lodge the nomination, but another added step is the candidate has to get a skill assessment for a Dharma visa, let's say pathway visa, whereas that's not required on the standard 4A2 visa. So why, if you're trying to attract people to areas of need, why add in further steps and further hurdles, including the skill assessment, which is not required generally? It just doesn't make sense. So I have no idea. When these things come out initially, it sounds wonderful, and then try and do one of them. And we've done quite a few, and then just see. In one instance, the other problem is that if a farmer in Australia wants to sponsor somebody, they want that person here yesterday. They're starting their harvest in a month or two. They don't want to wait. So with a standard 4A2 visa, you can turn these around sometimes quite quickly, 3 to 4 months. If it's through the Dharma program, you're lucky if you're going to get it through within 6 months. By that time, the farmer's just lost interest, or upfront, it just doesn't pay him, and it's just not worth the wait.
But presumably, though, if there is such a skills shortage, some people would persist with the protocol and still apply. I mean, you say you've done some of these applications. Have you got any of them through?
We did. We got one through recently. It's in South Australia. It was just so frustrating tearing our hair out, managing expectations with the employer in South Australia and the candidate in this case it's Namibia, which is next to South Africa. And we still, when you say have you got it through, we've got the sponsorship through, we've got the Dharma sponsorship through, we've got the labor agreement through, but now we're still moving forward to the next steps with the skill assessment. It's very frustrating.
Why do you think it takes so long?
So you have a priority skilled migration occupation list. It's very narrow, and it's probably narrow-minded. It doesn't cater for most of the, or let's say for most of the skill shortages in Australia, certainly not in the agricultural sector. So that's a good question. It would be good if this interview could be sent to the Office of the Minister of Home Affairs for him to actually understand exactly what I'm saying from somebody being on the ground with working through these visas.
What are some of the categories of the visas that are given the priority timing?
There's 44 occupations. It's, for example, chief executive officer, construction manager, accountant, engineers are on there, quite a few engineers. They've now added pharmacists, hospital pharmacists, industrial pharmacists, retail pharmacists. That's actually just paying lip service to pharmacists, and I'll tell you why in a second. And then all the nursing occupations are on there. I don't actually see one agricultural chef is on there. I don't actually see one agri occupation on this priority skilled migration occupation list. So it was in the newspaper yesterday that now pharmacists are added on. For a pharmacist from overseas you can't just sponsor them on a visa. They have to be licensed. It's not like a farmer. You sponsor them, they get the visa, they come over and start working. For a pharmacist, they have to be licensed. Try and get licensed as an overseas pharmacist in Australia. You have to write a full exam, as far as I understand it. And it's probably easier to come over on a student visa and study to be a pharmacist than to pass the exam. I've had a few clients from South Africa who are established pharmacists. They've had a look at the requirements to get a skill assessment as a pharmacist, and the licensing requirements would probably be the same. And it's almost impossible. So great, let's put pharmacists on the list because there's a massive shortage of pharmacists. I would like to ask the minister in 12 months' time exactly how many pharmacists have been sponsored from overseas. And let's ask him how many pharmacists have been sponsored in the last 12 months.
So what you're saying is they get here on these visas and then they need to retrain, or they need to sit another exam?
No, they can't get the visa. If it's a licensed occupation,
right?
Let's say like a pharmacist or a nurse or a doctor, you actually need some form of at least a provisional registration before you can get the visa.
And so what you're saying is that because it's very difficult to get that registration.
Yep, correct. Which means you're not going to get the visa.
Right.
So unless you're already registered, let's say you came over on a student visa and registered and became a pharmacist and went back to your own country, if you qualified in Australia and you're living overseas, sure, that's okay. But try and bring over a skilled pharmacist. I'd love to see that happen.
What about doctors? Do doctors have an easier pathway?
A little bit easier. They can come over with provisional registration. So there are quite a few South African doctors actually working in Australia at the moment. For them to get permanent residence, they have to have full registration, which means that they have to pass the exam. Let's call it the final exam, whatever that is. It is extremely difficult, but that's the medical profession. I think you want to keep a standard of, obviously, of medicine in Australia. So that's understandable. So doctors can come over with provisional registrations. I don't think you need to be writing exams for that. It's merely getting your qualifications accredited. So on a 482 visa, it is pretty doable.
So they come over here with the provisional qualification, but they can't practice until they sit the final exams. Is that right?
Correct. They can practice. They obviously have to practice under supervision, such as working in a hospital. That's okay.
Okay. And once they come over, they don't have to sit the exams before they get here.
Not for that, no, not for the 482 visa. Yeah, okay. I'm not sure with pharmacists if there's some form of provisional registration. If there's not, it's just a point even having it on an occupation list.
So Philip, tell us a little bit about these lists and the occupations that are on these lists, and how do they get updated? How do you find out about updates?
Yeah, so we get these updates all the time. Generally, the occupation lists are sort of overhauled once a year with the migration program. That, generally a new migration program kicks in from 1 July each year. So, for example, yesterday I heard on the news that there's a migration standing committee. They've identified skill shortages in Australia, and they've recommended X amount of occupations now be added to the list. That will be interesting. They also mentioned that since COVID, over 500,000 skilled temporary workers have left Australia. So can you imagine the skill shortage that's created in Australia now? So yes, skills are being added back, and hopefully that just creates opportunity for more migrants. Apparently they're going to increase the cap. They obviously put a cap on skilled visas. There's always a cap, but there was an even further cap put on during the COVID outbreak last year. So we'll see what occupations are on there and if they're relevant and what their criteria are to get people over the line with them. There's no point having an occupation where you make the skill assessment so impossible, like the pharmacy skill assessment, that there's just no one that's going to jump through that hoop.
So I didn't realize that. So every year they revisit the list of occupations. Is that right?
They do.
Okay, and presumably, and in fact, I know the answer to this, they would be taking off occupations as well.
Correct. So, for example, one occupation that's on the list that is just almost impossible, and I think no accountants were invited in the last round. If you're an accountant, which is on the list, it might as well not be on the list. For example, they've been talking about taking accountants off the list for years. They haven't. Obviously, it is a critical occupation. To get invited on a skilled visa as an accountant, you almost have to be shooting the lights out with your points. But as a skilled migrant, trying to immigrate as an accountant is extremely difficult right now, because I'm assuming there's a surplus of accountants. A lot of students graduate as accountants and they cannot get employed.
Right. However, you did mention that accountants are on the expedited list.
They are. So what that means is if you do, as a candidate, if you're lucky enough to find an employer to sponsor you, you'll sail through.
Oh, sorry. So just to clarify for people watching this video, so that information you just told us about accountants, that doesn't apply if you have an employer sponsor.
So sorry, let me clarify.
Let's clarify the situation.
Migration occupation list only applies to employer sponsors.
Got it. However, you just said that accountants there's a possibility, and there's been talk about accountants being removed from the list.
I don't think there's a possibility. I said there was talk about them once being removed. They're not being removed. So let me clarify. On an employer-sponsored visa, if an accountant has an employer to sponsor them, they will get through quite seamlessly because it's on the priority skilled migration occupation list for employer-sponsored visas. If you don't have a sponsor and you're applying for a skilled visa as an accountant, your prospects of getting up on it are, well, getting an invitation to apply for a visa are probably close to zero.
Okay. Can you just explain for people that might not be familiar with the immigration space, the difference between an employment sponsorship and being invited to come over here without? And so what are there jobs, in fact, that can get visas in Australia without an employment sponsorship?
Yes, correct. So broadly speaking, you have employer-sponsored category of visas, and then you have skilled category of visas. So if you have an occupation that's on the skilled occupation list for one of these skilled category of visas, and you meet the threshold criteria, such as being able to get a skill assessment, passing English tests, having enough points, then you submit an expression of interest. And the Department of Home Affairs will then decide whether to invite you or not invite you. If they don't invite you, you merely just sit in the cloud, if we can call it that. But if you do get an invitation, yes, without an employer sponsor, and you can get an invitation, then you apply for the skilled visa for one of the different visa categories.
Right. And those people, once they get the invitation, they can come to Australia and work for themselves or with their own ABN, or how would that look for them?
Correct. They can come, if you come in on a skilled visa, let's say the subclass 189, 190, 491. 491 is regional, where you're confined to a regional area. Even though, let's say, you got the visa based on your skilled occupation, let's say being an accountant, you can come in and do whatever you want. You can come in and open a coffee shop, or you can come in and work as an accountant. You can come in and work whatever you want to do. You're not confined to anything at all.
Right. So you're granted a visa, a working visa.
Yeah, you're granted a visa with full work rights and the right to live in Australia.
Got it. And usually are those visas have a pathway to permanent residency, or those visas are temporary?
Yeah, so some of them are already upfront permanent residency, 2 of them. The subclass 491 visa is a temporary visa, but if you live in the regional area that sponsored you for the visa for 3 years, then you can apply for permanent residence.
Got it. So can you just explain to people about the regional, the differentiation between working in a regional area and in the city? Because I do know there are some people on visas and their visas are limited. So they'll expire after a 2+2 and they don't have a pathway to residency. But if they go and work out in the in regional areas, can you explain how they might have a possibility to stay longer in Australia and why it's different?
Yeah, so you get these regional visas. I'll just categorize them right now. So in 2019, the government brought in the subclass 494 visa, which is an employer-sponsored regional visa, and the subclass 491 visa, which is, let's say, a skilled visa unrelated to employer sponsor. So if you're in a regional area, and let's talk about regional area. Some people think regional area is super remote. It's not. The whole of South Australia is deemed to be a regional area. The whole of Western Australia, so that would include Adelaide. The whole of Western Australia, including Perth, is deemed to be a regional area, and there are many others. Regional area is more or less every region in Australia outside of Sydney, Brisbane, and Melbourne. But if I can just zone in on that, a designated regional area now includes all of Australia except for Sydney, Melbourne, and Brisbane.
Fantastic. So potentially, could that be the Hunter Valley as well?
Absolutely. Blue Mountains, Hunter Valley.
Okay, got it. Great. Well, thanks. That's a good update.
So if you have an employer sponsor and you're working in a regional area, let's say on the subclass 482 visa, there's no pathway to permanent residence potentially on many occupations. But if that occupation is on the subclass 494 visa list, the regional employer-sponsored visa, you can be sponsored for I think it's a period of up to 5 years on that. And after 3 years, you actually can apply for permanent residence. So my advice to clients, interesting, you asked me earlier, what advice do you have to clients? I often tell them, get out of Sydney, get out of Brisbane or Melbourne, go regional, explore opportunities there, study there. So if somebody's applying for a student visa, I am informing them, don't waste your time studying in Brisbane, Sydney, or Melbourne. You're going to hit a dead end. Go and study regional, where there's more opportunities. There's work opportunities. You get additional points for studying regional. It's sort of the new go-to as far as I'm concerned.
If you do work in Sydney and then you get to the end of your visa and it's a dead end, and you then go and work in a regional area, you restart the process?
Yes, you do. You do restart the process. So if you want to fast track the process, kick off in a regional area.
If a company is based in Sydney, is it able to open a regional office and send its employees down there?
I think so. I think they would be. So provided you the location of the sponsored employment is regional, it's it can be done, I would think.
Yeah, so as long as the candidate is working and living in the regional area, then the employer sponsor, then the sponsorship can apply.
Yeah, correct.
All right, well, we've certainly covered some technical areas today on these visas, which will be very interesting to a lot of people, because I myself have been through the visa process. In fact, we've engaged you, Phillip, to help us out, or your firm to help us out with our visa application. So I am not a novice to the sponsorship process, and I am an employer sponsor. But having said that, given that I also had to ask all of those questions, it does show that this area is quite specific. And if you're not practicing in this area, often, that it's not something that you come across on a day-to-day basis.
Yes, exactly. So quite an interesting recommendation that I saw yesterday that was made by the Migration Standing Committee. At the moment, as you know, for the subclass 482 visa, you've got two different lists. You've got the medium-term occupation list, the regional occupation list, and the short-term occupation list, which you mentioned earlier about the 2 years plus 2 years. They brought that in, I'm not sure how long ago they split the occupation list like they are now. Maybe 2-3 years ago. Believe it or not, the recommendation was that there should be no distinction between the occupations on the temporary employer subclass 482 occupation list. So once again, they've implemented a system for whatever reason, and they're now purportedly going to reverse back to what works. What worked before. My submission, if I can make a one-line submission to the Department of Home Affairs and to the Minister, is they're always changing things, even things that work. I think there's a saying that if something's not broken, don't try and fix it. Try and fix what's broken.
What is the discussion that they're doing? So we currently have 3 classes of visa, so short-term, medium-term, and then...
Correct, 3 occupation lists, yes. So the recommendation now, and they have different visa outcomes and different visa pathways towards permanent residency. And in certain cases, like the short-term list, there's no pathway to permanent residency.
And are they recommending to take away that limitation to the short-term list?
That's exactly what I read, that they recommended taking away the various distinctions between the different lists and have one occupation list. And that's how it was maybe in 2017 up until then, and it worked perfectly. They then changed it, and it seems that it may now be being reversed. Right. Well, with some other changes that we don't even know about.
But that would be good news, though, for people on the short-term visa list, because potentially they could then have a pathway to residency.
Yeah, potentially. We'll have to see what caveats come in. There's nothing is what it seems, certainly not with visa legislation. So it will be interesting. But yes, possibly you could be right, hopefully.
And when do you think we would know more information around this?
I think generally in the visa space, in the legislation space with visas, things move very quickly. So it should unfold quite quickly.
So within the next 6 to 12 months?
Oh, yeah, I would say so. Absolutely.
So, Phillip, can you move from one visa to another once you've got the visa granted?
If you're actually on one of the regional visas, you cannot. Such as if you're on the subclass 494 already or a 491, you are precluded from moving on to another visa. But if you're, let's say, employed on a subclass 482 visa, yes, you can move on to any other type of visa from a 482.
Phillip, thank you. You've given us some really interesting insights into the immigration law space. Thank you for being on this interview today. And we look forward to talking with you again.
It's been good chatting. Thanks for your time.